A federal judge has ordered the Trump administration to fully fund federal food assistance and restore benefits for 42 million Americans. That judge criticizing the administration for ignoring his order last week to quickly restart payments for SNAP. Now, in the order, the judge writes, quote, faced with a choice between advancing relief and entrenching delay, it chose the latter, an outcome that predictably magnifies harm and undermines the very purpose of the program it administers.
What is up, everyone? Welcome. Sophia is here. So let's start. Trump's legal playbook has been consistent. Appeal everything, claim every privilege, challenge every subpoena, extend every deadline, run out the clock, and exhaust the opposition. The goal is always to push real accountability as far into the future as possible, making the cost of pressing forward greater than most adversaries can bear. That strategy, built and refined across hundreds of legal confrontations across 4 decades of business and political life, has one specific and identified vulnerability, one scenario that the entire architecture of delay and deflection is designed to prevent.
Even after the president posted on social media, SNAP benefits will be given only when the radical left Democrats open up government. The judge pointing to the president's own words, accusing the administration of defying the court's order and causing irreparable harm, saying, quote, the evidence shows that people will go hungry, food pantries will be overburdened, and needless suffering will occur.
Donald Trump, sitting in a witness chair under oath, answering specific questions on the record without the ability to have a lawyer respond instead of him, without the ability to issue a press release instead of an answer, without the ability to file a motion to dismiss the question. Just Trump and the oath and the question and whatever comes out of his mouth next being permanently part of the sworn legal record of the proceeding. And tonight, a federal judge has ordered exactly that. Not in 6 months, not after the next round of appeals. In 48 to 72 hours, show up, sit down, take the oath, answer the questions, or face contempt. Face the U.S. Marshals. Face a scenario that has been the theoretical endpoint of every accountability proceeding and is now the actual immediate reality of this one.
The administration was ordered to pay about half of the SNAP payments, what they had from that contingency fund that they had. That had created a lot of questions here during the White House briefing, Jake, where Caroline Leavitt was acknowledging the president's post, but essentially saying that they were still complying with the court order. Those were actually talking points that were sent up to Republicans on Capitol Hill. The judge took it very differently and saw it as basically a rebuke of his order to pay those SNAP payments.
Trump is frozen because there is no procedural move available that gets him out of this specific room on this specific timeline. The New York civil fraud trial gave everyone a preview of what Trump under oath actually looks like in practice. It is not the controlled and carefully managed performance of a man reading from a prepared statement at a press conference. It is an unfiltered and frequently contradictory and often legally damaging account of a man who is not accustomed to being in a setting where he cannot control the narrative, cannot redirect the conversation, and cannot simply refuse to answer and walk away.
Judge John McConnell saying, quote, people have gone without for too long. Not making payments to them for even another day is simply unacceptable. Vice President J.D. Vance arguing it's not up to the courts to decide.
In the midst of a shutdown, we can't have a federal court telling the president how he has to triage the situation.
The New York civil fraud testimony was a preview. The compelled federal testimony we are describing tonight is the main event. Every legal analyst who watched what happened in that New York courtroom when Trump sat under oath understands why the prospect of expanded sworn testimony covering not just the civil fraud, but the obstruction and the classified documents and the election interference and every other active proceeding where his testimony is legally relevant is the specific scenario that his legal team has spent years and hundreds of millions of dollars in donor money trying to prevent.
The administration had to pay those SNAP benefits in full for the month of November. Now, as you mentioned, this follows another ruling that he made last week, and after that, the DOJ, Department of Justice, said that they would comply, but only provide partial relief with a contingency fund.
It is the most important single element of the order in terms of foreclosing the delay mechanisms that Trump's legal team has used successfully to extend every previous confrontation with compelled testimony. The normal timeline for challenging a testimony order through the appellate process, filing a motion to stay, briefing the appeal, waiting for the appellate panel, scheduling the oral argument, receiving a ruling takes weeks at minimum and often months. Trump's legal team has used that appellate timeline strategically and repeatedly to push testimony deadlines past the point where they could produce consequences within the relevant legal or political window.
During a press briefing, and the press secretary, Caroline Leavitt, insisted that the administration was not going to defy a court order, that they were, in fact, going to go through the process to administer some of the benefits, some of the amount through a contingency fund. She says that the president meant in the future he did not want to tap into that fund, which is not exactly what he wrote.
The 48 to 72-hour deadline is specifically designed to make that appellate strategy unavailable. An emergency motion for a stay filed in 48 hours with a contempt order and U.S. Marshal custody as the alternative requires an emergency appellate response that appellate courts are extremely reluctant to grant absent a showing of serious harm that clearly outweighs the competing interest. The judge who issued the order has already ruled on the privilege claims and the immunity arguments that will form the basis of an appeal. Those rulings are in the record. The appellate court would have to reverse the district court's already issued rulings on an emergency timeline with no oral argument and no full briefing, a legal standard that is extraordinarily difficult to meet in 48 to 72 hours, even for a well-resourced legal team with excellent appellate lawyers. Think about what it means for a legal strategy that has always depended on the appellate timeline as the primary mechanism for converting a losing legal position into an extended delay. The timeline collapses the strategy. A strategy that cannot function within the available timeline is not a strategy. It is a surrender waiting to happen on the most unfavorable possible terms. The scope of the testimony matters enormously. The order covers multiple active investigations simultaneously. The fraud and obstruction investigations that are the primary stated basis for the order, plus the related financial and document handling questions that have been accumulated across the civil fraud proceedings, the classified documents case, and the broader obstruction investigation. Trump is not being asked to testify about one specific and bounded set of facts in one specific and bounded legal proceeding. He is being ordered to answer questions that span the full scope of the active legal landscape. Questions about financial valuations, about document handling, about conversations with advisors and lawyers and co-defendants, about what he knew and when he knew it, and what he instructed other people to do in response to that knowledge. The full breadth of the active legal landscape covered in a single compelled testimony session is what makes the order so specifically dangerous for Trump, beyond the simple fact of being placed under oath. Inconsistencies across different subjects in a single testimony session are easier to document and easier to prosecute as perjury than inconsistencies that emerge across multiple separate proceedings over extended time periods. A single sworn session covering the full scope of the active investigations creates a single unified record of what Trump said about all of it at the same time. That unified record is available to prosecutors in every active proceeding simultaneously, not as a piece of evidence in one case, but as a cross-cutting resource that can be used to test the consistency of everything Trump's team has been arguing across every proceeding at once. The privilege rulings have already been litigated extensively. The judge has already ruled that executive privilege does not apply to the specific categories of communications being inquired into because those categories involve personal and political conduct rather than the exercise of core constitutional presidential functions. The crime-fraud exception to attorney-client privilege applies because the communications at issue were used in furtherance of alleged crimes rather than for legitimate legal advice. The work product doctrine does not shield materials that were created in connection with conduct that is itself the subject of the criminal investigation. Those rulings are on the record. They are reasoned decisions that address the specific legal arguments Trump's team made. An appellate court reviewing those rulings on an emergency stay application in 48 hours would have to find that the district court committed clear legal error in resolving those well-briefed privilege questions. A standard that is extraordinarily difficult to meet when the district court has produced a reasoned written decision on each issue. The privilege doors are closed. The appellate pathway through the privilege arguments is effectively blocked. Without the privilege arguments, without the procedural mechanisms that have been the primary tools of the delay strategy across every previous confrontation, the only remaining response to the order is compliance or contempt. The perjury dimension is where things become truly dangerous for Trump. What happens under oath in the next 48 to 72 hours is not just a legal event contained within this specific proceeding. It is a sworn record that becomes available to prosecutors across every simultaneous active proceeding, and that creates specific criminal exposure for every statement Trump makes that can be shown to be false. The perjury statute is simple and brutal in the context of a witness who has spent years making contradictory statements across multiple legal and political forums. To commit perjury in federal court, a person has to make a false statement under oath about a material matter, a fact that is relevant to the proceeding, while knowing that the statement is false. The documentary record that prosecutors have assembled across the classified documents case, the election interference investigation, the civil fraud proceedings, and the cooperation materials is a comprehensive archive of what Trump and the people around him have said and done and communicated internally about every significant factual question that will be covered in compelled testimony. That archive is the perjury trap. Not a trap that prosecutors set deliberately, but a trap that the documented record itself creates whenever a witness who has made contradictory statements across multiple forums is placed under oath and required to give a single definitive sworn account of the facts. Every statement Trump makes under oath in that room will be immediately and simultaneously checked against the documentary record across every active proceeding. Every answer that diverges from what the internal records show is a potential perjury count. Unlike the political and public forums where Trump has been making inconsistent statements for years without direct legal consequence for the inconsistency, the sworn testimony session creates a single document that can be used to prosecute the specific false statements it contains. Regardless of what Trump argues about context or meaning or interpretation afterward, the next 48 to 72 hours will produce a legal artifact that will be examined and cross-referenced across every investigation simultaneously. The contempt scenario is where the judge's explicit authorization of U.S. Marshal custody as the enforcement mechanism becomes critical. That authorization is not a rhetorical threat. It is a specific and operational directive that the Marshal Service is now positioned to execute if Trump refuses to comply with the testimony order within the specified window. The U.S. Marshals are the enforcement arm of the federal courts, officers of the judicial branch whose institutional responsibility runs to the court rather than to the executive. Their authority to enforce a valid court order, including a contempt order that authorizes custody to compel compliance, is not dependent on the agreement or cooperation of the Secret Service. The constitutional authority of the federal courts to enforce their own orders through their own enforcement arm is the foundational institutional authority of the judicial branch as a coordinate and independent branch of government. A sitting president who refuses to comply with a valid federal court order compelling his testimony and who is then subject to a contempt order authorizing marshal custody is exactly the constitutional scenario that the separation of powers was designed to address. The question of whether the Secret Service would stand between the marshals and a president who has been ordered into custody pending compliance with a testimony order is the constitutional showdown that makes this compelled testimony order the most acute and most immediate separation of powers confrontation in the entire history of Trump's legal exposure. That showdown has a legally clear answer in the constitutional framework. The courts can enforce their orders. The marshals can execute contempt orders. a president who defies a valid court order is not above the law, regardless of what the Secret Service's protective mission requires in other contexts. Legal analysts describing this as make or break are not using hyperbole. They are describing the specific legal dynamic that makes compelled oral testimony under oath categorically different from every other category of evidence or proceeding that has been part of this legal story. Documentary evidence, however comprehensive, requires prosecutorial interpretation and jury evaluation before it produces consequences. Witness testimony, however cooperative, requires credibility assessments and cross-examination before it can be used to build the case against the primary target. But Trump's own sworn testimony, his own words, his own answers, his own choice of what to say about specific facts when he cannot redirect or delay or delegate, is the most direct and most legally unmediated form of evidence available in any proceeding. If he answers truthfully, he incriminates himself directly in his own words, and those incriminating statements are immediately available to prosecutors across every active case. If he refuses to answer on valid legal grounds, he gives prosecutors the evidentiary record of specific areas where he is asserting protection from self-incrimination, an assertion that juries in civil proceedings can draw adverse inferences from, and that prosecutors can use to identify the specific factual areas where the documentary record is most likely to establish criminal conduct. If he answers falsely, if he makes sworn statements that the documentary record contradicts, he creates perjury exposure that is independent of every other charge in every other proceeding. That is among the most straightforwardly prosecutable federal crimes available because the false statement and the documentary contradiction are both already in the record before the testimony even concludes. There is no version of sitting in that witness chair that does not produce devastating legal consequences. That is exactly why Trump's legal team has spent decades and hundreds of millions of dollars preventing him from ever sitting there. The 48 to 72-hour deadline is the single most legally significant detail in the entire compelled testimony order, because it is specifically designed to foreclose the procedural delay mechanisms that have defined Trump's legal strategy across decades of litigation. The one procedural tool that has always been available, the appellate timeline that converts a losing legal argument into months of additional delay, is specifically and deliberately foreclosed by the structure of the order itself. Trump's legal team cannot file an appeal and wait for a ruling on the normal appellate timeline when the contempt order authorizing martial custody is operative in 48 hours. They can file an emergency stay application, but the standard for granting one clear legal error in the already issued rulings, irreparable harm, likelihood of success on the merits, is extraordinarily difficult to meet in 48 hours when the district court has already issued reasoned written decisions on each of the legal arguments the stay application would need to raise. The deadline is not just an administrative detail. It is the legal mechanism that makes the order different in kind from every previous compelled testimony demand that the delay strategy successfully managed. A deadline that cannot be survived through the normal appellate process is a deadline that produces compliance or contempt. There is no third option available on this timeline. The specific authorization of U.S. Marshal custody as the contempt enforcement mechanism signals that the judge has assessed the probability of non-compliance and has specifically and deliberately structured the order to make non-compliance as costly and as publicly visible as possible. Judges do not include explicit marshal custody authorization in contempt orders for witnesses who they expect to comply without resistance. That specific provision is included because the court has assessed the record of the proceedings to date, the documented history of delay, the documented history of stalling, the documented history of misrepresentation of what court orders require, and has concluded that the enforcement mechanism needs to be explicitly stated and explicitly authorized before the order is issued, rather than after noncompliance creates the need to escalate. The marshal custody authorization is a judicial prediction about likely behavior that is also a judicial statement about the consequences of that behavior and the public visibility of those consequences. The image of U.S. Marshals authorized to take a sitting president into custody pending compliance with a testimony order is itself a form of judicial pressure that operates independently of whether the custody is ever actually executed. The political and public cost of being the subject of a marshal custody authorization is significant. Even if compliance ultimately prevents the custody from being carried out, the authorization exists. It is in the order. It is part of the public record. Everyone watching knows that the judge has specifically determined that custody is the appropriate enforcement mechanism for this defendant's non-compliance with this court's orders. Every possible response Trump can make to the compelled testimony order produces devastating legal or political consequences that cannot be managed through the normal tools of press releases and social media and political spin. The compliance scenario: Trump shows up, takes the oath, and answers questions, produces sworn testimony that is immediately available to prosecutors across every active proceeding as a cross-reference for every inconsistency with the documentary record. The self-incrimination refusal scenario: Trump appears but invokes Fifth Amendment protections on specific questions, produces a documented record of specific areas where he is asserting protection from self-incrimination that civil juries can draw adverse inferences from, and that prosecutors can use to identify the specific factual areas where the documentary record is most likely to establish criminal conduct. The non-compliance scenario: Trump refuses to appear and faces contempt, produces the marshal custody confrontation, the most politically and constitutionally dramatic scenario in the entire history of his legal exposure. All three scenarios are legally devastating in different ways. None of them can be managed into a neutral outcome through political spin because the record produced by each scenario